As a society, we like to consider ourselves civilized, decent, and protective of those who require protection within a moralistic and ethical construct. We also like to believe we have the good sense and social awareness to consider situations upon their own merits with the ability to adapt when we learn more and become more knowledgeable. Each time we do this, we pat ourselves on the back as we climb another step higher and manage to balance our thoughts, beliefs, and feelings through the concept of a new precedent. Our precedents then run a logical course of being created, exercised, and tested under the stresses and pressures of real-world circumstance to ensure their effectiveness and robustness over time. There are so many examples of where we have collectively pushed forward and demonstrated our evolution in cultural sensitivities and common sense. As a society, we are of course fallible, subject to errors in judgment, and just plain getting it wrong despite our ever-increasing knowledge and sense of right. Sometimes, however, we fall victim to the failing of the more things change, the more they stay the same. And this may indeed be one of those times, as we continue to examine the not-so-black and white intersection of self-defense and domestic violence in our society on this, the next episode of Just Lawful.
Adelaide is the perfect place to set a horror story. You know why all those films and books are always set in sleepy conservative towns? Because sleepy conservative towns are where those things happen. Exorcism, omens, shining, poltergeists. Adelaide is Amityville, or Salem, and things here go bump in the night.
Welcome again to Just Lawful, where things do indeed go bump in the night. My name is Daniel Panozzo, and I am once again joined by my co-host, Sean Fuster.
Daniel, thank you, and listeners, thank you very much for tuning in once again.
Before we begin, as always, a huge thank you to everyone who has listened over our past X number of episodes. It's getting up there. We've been doing this for a while, and I must say, Sean and I are just incredibly grateful for the opportunity and privilege to keep doing this. So,
very much so, very much so.
If you haven't heard our previous episodes, we would strongly recommend and also greatly appreciate you going back and listening through iTunes and Spotify, rating, reviewing, getting us out there. The more you give those 5-star reviews, etc., it actually bumps us up the algorithm and gets our voice out to those who may be searching for this sort of content. We couldn't thank you more than that. We'd love to hear from you in doing that. As you may know, if you've been following along, the next episode is going to follow on from our last one, and in terms of that, we just want to give the warning again that if you do find anything in this episode distressing, we want you to make use of the following support resources: the Domestic Violence Crisis Service on 1300 782 200, the Domestic Violence Gateway Service on 1800 800 098. The National Sexual Assault, Domestic and Family Violence Counselling Service on 1-800-RESPECT. Sean, you had some others that you wanted to give out to, obviously, and that's obviously for our local, but international and interstate, obviously, please make use of your local resources. And Sean?
Yes, because we've got to acknowledge here that we are two white men talking about an issue that more often affects, and almost completely always affects, women and children. So don't just listen to our voices on this. We'll give you the benefit of our experience. We'll give you the benefit of what I've seen in court. But to understand this, you need to listen to the people who really know what's going on. Visit embolden.org.au. Check out White Ribbon Australia. Check out the website au.reachout.com. Go on Facebook and search for Destroy the Joint. Their work on domestic violence, intimate partner violence, and gendered violence is probably the A1 level of work in this country. And of course, journalists like my colleague Lauren Novak and Georgie Dent, who are just doing incredible work in this space day in, day out.
Absolutely. We're not going to dally around this. We spent the last episode and we went through a couple of cases to start with that really set a precedent, and then a second case that really challenged that and saw the evolution and the movement and the shift in the thinking of our justice system around this domestic violence and where it intersects with a self-defense aspect of where does it become that, what is reasonable force in that sense, what is too much in that sense, and we saw a real shift from giving a not guilty plea originally, and then in the second case we actually pled guilty to excessive self-defense, and still got the same outcome, which was those suspended sentences. So we saw in that, as I said, Trent, the evolution of understanding what that looked like from 2003 through to 2008 when the second case was.
That's right.
So we saw a shift in that sense.
And the sentencing for that second case, Noreen Wheater, was actually by 2009. So incident in 2008, sentencing by 2009. Safe to say that by 2009, the South Australian courts had accepted that women who are suffering from domestic violence may act in a way to save their lives, that is excessive as far as the law is concerned, but there can be a just and merciful outcome in sentencing leading to suspended prison terms. That's the state of play as of August 2009. But to talk about our next case, we need to rewind a little bit.
Okay.
We need to go back to December of 2008.
Okay.
And we need to go to Unley. For those who are not in South Australia, Unley is one of the higher socioeconomic areas, one of the richer areas, leafy green, eastern suburbs kind of vibe, if you can imagine that. And on this particular morning, $1 million house was burning.
Okay.
Everyone had woken up just to find this house ablaze.
Right.
And one of the owners of the house was standing on the sidewalk with her children. This was a woman by the name of Rajini Narayan.
Mm-hmm.
And someone said to her, "Ms. Narayan, what happened? Why is your house on fire?" And she replied, "My husband loves another woman. He hugs her. I'm a jealous wife. His penis should belong to me. I just wanted to burn his penis so it belongs to me and no one else. It's just his penis I wanted to burn. I didn't mean for this to happen."
Okay. There's quite a bit to take in that. Okay.
To say the least.
We are talking about precedents around an intersection of domestic violence and self-defense here, yet we are now talking about a burning $1 million house, and we're talking about a lady standing outside her burning house saying she's a jealous lover and wanting to burn her partner's penis.
And we've got to talk about the entire context for this,
Right.
because, as I said, the South Australian law by this point has accepted that when there is physical violence done in response to ongoing physical violence,
Right.
in a situation of life preservation, we accept that is excessive self-defense.
Right.
We heard the judges last time. Rare and exceptional circumstances. Cases such as yours in these specific circumstances. The case of Rajini Narayan, who was charged with the murder of her husband Satish, he was an engineer, would test that to its absolute breaking point.
That would stand to reason it would, because from what you've said, the small part we understand at this stage, there doesn't seem to be the same circumstance as potential threat of violence or harm as we saw in the first two cases from our last episode.
Think about what we keep talking about, which is self-defense.
Yeah.
The analogy I keep using, you come at me with fists, I come at you with a chair, it's
Correct.
excessive self-defense.
Right.
What kind of act could precipitate setting a house on fire? What level of defense are you taking in order to burn down $1 million property at Unley? I just can't fathom anything that actually fits that dynamic.
No, I don't know either, Sean. I was really hoping those questions were rhetorical because I don't have answers for those either.
Well, I always have rhetorical questions for you, Daniel. It's okay. I do have the answers because, as per usual, this is a case that I covered.
Great.
And it was certainly unique. Prosecutors alleged, following Ms. Narayan's arrest, that Satish was asleep when she doused his genitals with methylated spirits and then set him on fire. The only reason the house burned down was because, understandably, he jumped out of bed, knocked over the bottle of spirits, set the curtains on fire, and then the rest of the house burned down.
So her intention wasn't to burn the house down as such, it was just to burn her partner's genitals.
Now, in murder, you don't have to have an intent to kill.
No.
If you are recklessly indifferent as to whether or not death could result from your actions as a logical outcome of what you do, you can still be found guilty of murder. Let's be fair, setting someone's genitals on fire is more or less going to lead to death in most cases.
Yeah, look, certainly you would possibly think that, and I guess by the rationale of what you laid out of how that plays out, hence the reason we have a crime here where we have someone charged with murder.
But the reason we're talking about it right now in this episode is because what prosecutors allege next.
Okay.
They said that the motivation for the penis burning was 2 decades of beatings
Right.
administered by Satish
Okay.
prior to the discovery of an affair. Now, see whether this sounds familiar to you.
Mm.
According to both prosecution and defense in this case, Satish had been beating Miss Narayan throughout their marriage
Mm.
since it was arranged in India in 1986.
Okay.
Arranged marriage overseas, moved to this country, the beatings continue. You see where I'm going here? I can see it dawning on your face.
There's a lot of similarities there to the case we covered, the Abrahimzadeh case.
That's right. And then she discovers that her husband is having an affair, that he is giving financial support in an ongoing fashion
Right.
to this other woman. And worse yet, all of the wages that Miss Narayan is earning are going straight to the other woman. So she's not garnishing her own family's income, not looking after her own son and daughter with her money. Her money is being sent by her husband to his mistress.
It's a further indignation of that situation.
And that is a level of psychological torment on top of the physical torment that has been going on. But how do you get from that to deciding to burn your husband's penis?
That, I think, is the question at the moment, Sean. That's certainly a question in my mind. Getting to that, and then how is that potentially? And we heard potentially 2 decades of beatings. I get that. This, I think you made the point, is really going to start to test that precedent that we'd already talked about in the first episode.
Especially when you involve a Hindu love story, an angel candle, and a demon king. So, Daniel, the similarities are there to the Abrahimzadeh case. A long history of domestic violence within a marriage that had been arranged, a move across countries, children who were supportive of their mother, terrified of their father. That was a facet of that as well. The differences are what make this case unique, though.
Okay.
So when Satish Narayan married Rajini in 1986, he walked around a fire pit to mark her with a red sindoor dot and claim her as his own, as part of their culture.
Okay.
And that recalls the traditional Hindu love story of Lord Ram, who proved the purity of his wife Sita with fire after rescuing her from a demon king.
Right.
Reason I'm telling you all this is because Lord Ram and Lady Sita were Rajini Narayan's idols.
Right. Okay.
As far as she was concerned, they were the perfect marriage and exactly what she aspired to be like.
Okay.
So imagine that in your mindset as your husband beats you daily, multiple times a day.
Right.
The mentality that developed within Ms. Narayan was one of acceptance.
Yeah.
Because, like Gwenda Savchik, the only way to clear herself of a murder charge was to take the stand and give evidence.
Okay.
She made that decision rather than speak through silence. She was going to answer the assertions.
Right.
And she said, I did not like to be beaten, but I told myself I had to be better. I have to try harder.
Right.
That I deserved it because in my mind, I was not the perfect wife for my perfect husband. I idolized him. He was my hero, and I never spoke back to him because you do not fight with your God.
Wow. Okay.
That's a stark difference right there.
Yeah, absolutely.
From what was going on in the Abrahimzadeh household, where that was a perversion of Persian beliefs.
Yes.
And completely twisted.
Yes.
This was an adherence to a doctrine, a mindset, a belief, a set of ideology that left her a victim to her own choices.
Yeah, that cultural aspect of that, which was deeply seated within her, clearly in her concept of what a marriage should be like and the marriage she aspired to be and the wife she aspired to be. And as you said, as part of that process, as she said herself, held her husband on a pedestal of a godlike symbol, which she aspired, she needed to do better, which clearly fed into that, I'm not good enough, I'm not doing it. And as she said, she almost felt she deserved that treatment.
And she absolutely did not. She became a victim of her own mindset, but she was not a deserving victim of what Satish was doing to her day in, day out. All that changed when the affair was discovered.
Yes.
Now, again, in the Abrahimzadeh case, that was where the entire family rose up, stood as one and said, we will not accept this any longer.
That's right.
Ms. Narayan didn't quite do that.
Okay.
She chose to go to a fortune teller to actually get some idea of what she should do next.
Right.
So we've got the Hindu mixed in this now with this fortune teller. And the fortune teller gives her an angel candle and says, this will help you light the way.
Okay.
As Ms. Narayan recalled on the stand, a bizarre idea came to me. I would use a candle to burn the tip of Satish's penis. It would be like a circumcision, or just like the red dot he had placed on my forehead at the wedding. I felt like I had all the powers of the goddess to save my husband, my lord, and it did not occur to me that it was going to be dangerous.
Yeah, right.
So on the night before the fire, she walks into the bedroom holding a small tin lid of kerosene and the angel candle. Satish looks at her and says, "What are you going to do with that?" She says, "I'm going to burn a dot on the tip of your penis." He responded, "No, you won't, you fat, dumb bitch."
Yeah, right.
In that moment, almost 20 years of violence, of suffering, of trauma came to a head.
Yeah.
She snapped, she threw the kerosene on him and threw the candle on him.
Right.
And we all know what happened next.
Okay, so we now understand how we got to the point of that act. And, as you said, 20 years, 2 decades of beating, violence, all of that bubbling up. And clearly, by your own sort of words there, well, not your words, I shouldn't say, but your recounting of that, clearly such an act of disrespect shown towards her as well.
Now you understand why the prosecution was so convinced that this was murder. In the black and white mentality of the courtroom, you have an option to walk away at that stage. You do not have to throw the kerosene. You do not have to tip the candle over. You don't even have to try to burn the dot on the penis anymore. You can just go, "Oh, this was a bad idea.
Yep.
I'll turn around and go back to bed." Instead, she reacted in anger, understandably so.
Yes.
And this was the consequence. So that's why they were pushing that this is murder. We refuse to accept anything else. Defense was saying this is the outcome of decades of physical and psychological abuse.
Right.
And here's a new concept that enters into the legal lexicon right now.
This is where I was wanting to understand. So now that we put this back in the courtroom, how does this sort of weave, I guess, through this process of how does this step into the concept of testing that earlier precedent?
Well, we're back in Savchik territory. Savchik established the precedent of violence can be met with violence, and that can be excessive self-defense. This is, where does psychology add into that as well? There was no threat, no danger to Regina Narayan in that moment.
That's right.
But there would be the next day.
Okay.
Because there's no way that Satish was going to allow such an affront to stand. He was going to get up in the morning and beat her.
Right.
Could it have been worse? Was she afraid for her own life in that moment? Did that form part of the thinking to throw the candle at that time?
Yeah.
The jury was asked to accept that that's what was going on.
Okay.
That she was in such a psychological state of what they call arousal, combination of fear, of irrational thought, of confusion, of sadness, of betrayal, that it all manifested in that moment.
Okay.
And the jury was told, we're not saying our client is not guilty.
Yes.
We're saying she's not a murderer.
Right.
She absolutely killed her husband, but this is manslaughter.
Right.
This is excessive acts. This is a new form of excessive self-defense.
Okay. So with a new idea or I guess concept to build into this, we've put this to the jury. How did they find?
The jury found her not guilty of murder and guilty of manslaughter. They accepted the argument put forward by defense.
Okay. So at this point, before sentencing, we've got to the same conclusion of where guilt lies in this sense, and where the responsibility is. You are guilty of that excessive self-defense. Sentencing.
Here's the wrinkle.
Yeah.
Like we needed another one. The judge hearing this case is Justice John Sulin. Justice Sulin sentenced Ziola Abrahimzadeh for the murder of Zara Abrahimzadeh.
Right.
So he has sent a domestic violence killer to jail for murder. Now he's being asked to determine this matter.
Yeah, which is just, as you said, another wrinkle.
So keep in mind, Gwenda Savchik stabbed her husband with a samurai sword.
Yes.
3-year suspended sentence.
Correct.
Noreen Wheatra stabbed her abusive partner in the heart while being choked.
Yes.
5-year suspended sentence.
Correct.
Regina Narayan, a 6-year sentence, suspended on condition of a 3-year bond.
Okay. So a longer sentence, however, still same outcome of a suspended sentence.
That's right. Justice Sulin said there's no doubt, Ms. Narayan, that your thinking was unrealistic, muddled, and illogical. For the first time in your life, you had confronted your husband and found the courage to be assertive to the person who had mistreated you. His response was to treat you with disdain, dismiss you, and turn his back to you. And you snapped. You were shattered that you had finally defied him and just been betrayed all over again. Although it is often said that a suspended sentence is not a sentence at all, it is wrong to regard it as letting an offender walk free as if he or she has not been punished. It seems, Ms. Narayan, you have suffered a great deal already. There's echoes of Justice Mulligan
Correct.
in Savchik right there. You can see the through line of thought.
For sure.
To say this decision was unpopular would be a gross understatement.
I can imagine. I could imagine there would have been a lot of people that said, yep, on the basis of everything you're saying, she still did that act and could have taken an alternative.
Well, to be base for a moment, there were also people that were just going, ha ha, Lorena Bobbitt, that infamous United States case involving genital mutilation. People went for the low blow. They'd been looking at this case for a while as a bit of a giggle, unfortunately. Yeah. There were people in my own newsroom that had that kind of attitude. So when this sentence came back, the Advertiser ran an online poll. 63% of respondents called it unjust. This is November 2010.
Unjust in the sense that
she should have gone to jail.
Right, that's what I was thinking.
And the DPP agreed.
Okay.
The DPP did not let this one go. Now Judge, then DPP Adam Kimber, who you'll remember from the Hillier murder. And folks, I'm doing this deliberately. You need to see the connective tissue between all of these cases. Adam Kimber said, this sentence will fail to deter other battered wives from taking up arms against their assailants. He told the Court of Appeal, what if she had picked up a knife with the purpose of slicing his penis and then plunged it into his back? With all due respect, Mr. Kimber, I think you'd missed the point of several years of legal evolution.
And I think that's a very long bow to draw between his hypothetical situation and the one we actually saw unfold.
Exactly right. You can't play what if and fail to deter other battered wives from taking up arms against their assailants.
So you're admitting that she was a battered wife in that sense, and you're saying that they... I'm sorry, but is that an implication that you should just roll over and take it?
Or, you should just leave, perhaps.
Yeah, okay.
Fortunately, the Court of Appeal rejected that outright. Mr. Kimber, you've not adequately characterised the offence. Her motive was not jealousy. It was to save the marriage and keep the family together. The sentence stands.
Okay. So the DPP appealed and that appeal failed?
Absolutely.
Okay.
So we seem to have reached a new high watermark. By this point, we have recognised violence for violence and we have recognised violence for psychological abuse.
Okay.
We have gotten a very holistic picture of the sorts of abuse that can be perpetrated and the sorts of results that can come from the extremes of that abuse.
Okay. And, throughout that process, as you said, so far these three cases have all ended with that same. There is a sentence in place for that charge. However, they have all been suspended.
That's right.
So there's commonality so far.
That's right.
Sean, we started the last episode at 2003. By my reckoning, after this one, the Narayan case, we're around about 2011, thereabouts.
Correct.
We've had the verdict handed down, the sentence appealed by the DPP, and it's fair to say, as I said at the start of this episode, we had a precedent that was set back in 2003. It's now kind of been pressure tested in a real-life environment. It looks like we're now the second time that we've covered, in the cases we've spoken about, we're pretty firm. We've got this in place. We know where we're at. This precedent is now good to go, right?
Absolutely. Set by Savchik, reinforced by Wheatra, and then well and truly tested to its limit by Narayan.
Right.
You'd be forgiven for thinking that that was the lay of the land going forward.
Yes, I would.
Oh, I'm sorry. You thought that was the lay of the land going forward?
Well, I'd like to hope that we have pressure tested it, and that's where we stand.
If I asked you to give me odds on how long the precedent stood after Narayan, if I warned you ahead of time that it had been knocked down, and I asked you how long it survived after the Narayan decision, With what you've learned of the South Australian legal system over this show so far, what would your expectation be?
From what I've learned of the South Australian legal situation, I wouldn't be able to give you an answer because it is way too unpredictable.
Yeah, that's fair. 18 months is the answer.
Sorry, so we've gone from 2003 to 2011, so 8 years or 9 years thereabouts of pressure testing this precedent.
Developing social conscience, developing community expectations, developing discussions.
The cultural sensitivities that we hopefully have evolved to understand and accept, and even tested that latest version, when it's been appealed by the DPP, it's been upheld as correct, and you're telling me 18 months later, it all falls apart.
18 months later, it completely falls apart, and this is in the case of Catherine Therese Collier.
Right.
Now, her incident happened just 12 months after the Narayan incident.
Okay.
So we're talking December of 2009.
Yes.
But the case wouldn't be resolved until October of 2012.
Right.
So keep that in mind for your
Yeah.
timescale here.
Sure.
You might want to write this down. She pleaded guilty to the manslaughter of her partner, Troy Fraser Hannah.
Okay.
Troy Hannah was 10 years younger than her.
Mhm.
They were involved in what the court heard was an intense and destructive relationship.
Right.
Ms. Collier was a bed and breakfast owner,
Mhm.
independent businesswoman. She kept this business going in the hope that it would improve their relationship.
Okay.
Unfortunately, it didn't.
Right.
There was, according to what we heard in court, a lot of abuse of alcohol on her part,
Right.
on his part, abuse of drugs on his part,
Mhm.
breakups, getting back together,
Sure.
disagreements.
Mm.
At one stage, physical injuries
Right.
inflicted upon her from him.
Okay.
This all came to a head, as I said, in December of 2009
Yeah.
at the bed and breakfast. Mr. Hannah punched Ms. Collier several times, causing an injury to her lip. The argument continued downstairs. He continued to attack her. So, in a circumstance that won't sound unfamiliar, she grabbed a steak knife from the kitchen bench,
Mhm.
stabbed him once, and immediately called an ambulance.
Right. Okay.
Unfortunately, he died as a result of his injury.
Right. Yes.
She pleaded guilty to manslaughter on the grounds of excessive self-defense.
Okay.
She was in fear for her life. What had been going on?
So something very, very common, not unfamiliar to what we've heard so far in the lead up to this.
I don't want to call it textbook in that sense, but
No.
it's very much similar to what we've heard.
It's almost carbon copy so far.
Yeah, and go you one better. It's before Justice John Sulan,
Okay.
who has just finished hearing Narayan,
Yes.
who has also been involved, as we know, in the Abrahimzadeh case.
Okay.
So you can imagine the shock on my face sitting in court,
Mm.
and especially on Miss Collier's face, when Justice Sulan sentenced her to 3 years and 9 months jail and refused to suspend the sentence.
What was the justification for not suspending in this instance?
Well, he said that the violence went both ways.
Okay. What am I missing a part of evidence or something here that shows that? Because so far I haven't necessarily got that.
Well, unfortunately not. This is the thing. The drunkenness
Mm.
was mutual.
Mm.
The drug abuse was singular on his part.
Yes.
But the violence went a bit back and forth.
Right.
And as a result, we ended up in a situation where we're no longer talking necessarily in the court's eyes about an incident of domestic violence. We're talking
Okay.
about an incident
Yeah.
that has occurred in the context of overarching domestic violence, but not a domestic violence incident.
I think I'm not going to be alone when I say there's going to be a lot of people listening to this going, but hang on, it was a violent situation in a domicile situation. Therefore, doesn't that make it a domestic violence situation? Whether it's because it sounds like we're saying this is an isolated incident outside of what seems to be a continuing process of a relationship, which is rocky at best as we understand, which is that textbook concept of domestic violence.
But you've nailed it right there. The law sees it as an isolated incident
Yeah.
within an overarching context. And again, we can go back to the death of Jack Hanley.
Mm.
The one punch thrown by Reese Watherston
Mm.
within that brouhaha between young men who are
Sure.
high on nozzies.
Yeah.
That was the incident that needed to be looked at, forensically picked apart and assessed and judged. The judge is not there to look at the entire history between Troy Hannah and Catherine Collier.
Yeah.
He's there to look at that moment, that incident. Yeah, I
That's
can
gonna be
see how
very-
uncomfortable you look.
Well, that almost feels very tenuous, and I'm not criticizing because far more learned than myself to sit on the bench and adjudicate these things. It just seems very tenuous to say we're going to look at this one moment instead of an entire cacophony of a relationship, which was of a very similar veracity for the whole situation.
And look, with the greatest of respect to Justice Sulan, it feels from an outsider's perspective to
Yeah.
be an artificial construct.
And yeah, absolutely.
But that's the way the law was written. So despite all the moves that we'd made forward
Yes.
through all these other cases we'd covered, there still existed this loophole within law that turned into a magnifying glass and
Yes.
magnified this one incident and said, I'm sorry, Miss Collier, because it was a back and forth incident,
Wow.
you don't get the benefit of a suspended sentence like everybody else has.
That seems just very, very bizarre on the surface.
But it gets worse. There was no situation in South Australian law in that period of history so bad that it couldn't be made worse by the government of the day. Now, that's my personal opinion.
Okay.
There are people out there that are going to disagree with me on that, but I'll ride that horse till it falls over.
Okay.
That government's chief law officer was a man named John Rao.
Let's put that one aside. What was the situation that John Rao was involved in?
Well, John Rao was the Attorney General of South Australia at the time. And for a bit of context, the government for whom he worked, the Labor government here in South Australia, was known as a law and order party.
Okay.
There was a famous politician that was a member of their ranks who said that when it comes to imprisoning people, we should pack them, rack them, and stack them. Great, okay, sure, let's just fill the prisons and not worry about rehabilitation. There was a prosecutor who once, in my opinion, correctly noted that the Labor government liked to rush through, not think through, its legislative changes. Some of the things we've seen over the past couple of years in South Australia unwinding Labor government decisions really do put some sufficient power behind that concept. Right now, we're 2 years post the Collier case.
Okay.
And John Rao decides in November 2014 that we're going to rewrite the law on serious offending.
Okay.
Criminals who commit violent offences must serve some time behind bars and can no longer receive wholly suspended sentences. If you receive a penalty of 2 years or more for manslaughter or causing serious harm, you must do some time behind bars.
So we're taking away the opportunity to suspend those sentences regardless of the situation.
You can have a suspended sentence after you've done a couple of months behind bars or a year behind bars, but you can't go straight home. You cannot have the leniency that was extended to an Orion, to a Wheatra, to a Savchik. Now, of course, Mr. Rao was not targeting women involved in domestic violence situations. He was targeting thugs. As he said, people who commit serious violent criminal offences should have to spend some time in prison, and these changes will ensure that happens, delivering on our election promise. This behaviour is not going to be tolerated. The community expects that serious violent offenders serve time behind bars, and the government agrees. It is entirely appropriate that these thugs spend time in jail. Well, that's great. The problem with a drift net is that you kill turtles at the same time. And this was a drift net.
Yeah, this is that catch-all, one-size-fits-all, the best fit for the most majority situation.
And it shows a lack of thought because domestic violence campaigners immediately pointed out, hang on, what about the Savchiks, Wheatras and Narayans of the world? Because all three of those women would have had to go to prison.
Correct.
There would have been no understanding of their circumstances. Justice Mulligan in Savchik would have had to say, you're no threat to the community whatsoever. But because the law says I have to put you inside, you must do at least a month in jail.
Okay.
I mean, how much more are we re-traumatizing and re-victimizing these women who have made the ultimate stress decision, taken the ultimate action they can never give back? Look at Noreen Wheatra. She never forgave herself for what she did to Ross Callion. Regina Narayan, her kids later said that she was sleeping on the floor and denying herself material possessions as penance for killing her God.
Yeah. I'm intrigued. Just really quickly, you said that domestic violence advocates immediately decried this. Did we get any response, or when that was put forward, did we get any response from John Rao to those circumstances of what about these situations?
Do cricket chirpings count as a response? No, none whatsoever. Okay. The government had decided that this is the way it was going to be.
No correspondence.
No correspondence entered into. And this is the thing. The reason I've told you about Catherine Collier and the legal change, right one after the other, is not just because they happened right in time, but because they set the playing field that has all but neutered the Savchik decision, that has all but overturned and erased the Narayan decision.
Yeah.
The way that cases are handled now are handled as a combination of Collier and the law change. And when I say now, I mean as recently as May 2021.
Right.
Because now we come to the fifth of those cases
Sure.
that has defined the law in this area in South Australia, and that's the matter of Crystal Sue Graham.
Okay.
Crystal Sue Graham, very young woman, moved in with an older friend.
Mm-hmm.
He had a son. Son's name was Kane Bowman.
Mm-hmm.
Now, several people out there are probably pricking up their ears at Kane Bowman. Yes, that is the Kane Bowman you think. The man who ran down and killed father of two Kieran Hayward in 2015. The Kane Bowman who had never held a driver's license. Killer driver Kane Bowman. His father befriended and looked after Crystal Graham when she was in some serious personal strife.
Okay.
Gave her a place to stay, looked after her, a safe place to live. She and Kane struck up a conversation, a correspondence through prison. They fell in love. Kane's father said, look, this isn't a good idea, Crystal. But no, she was in love. When Kane came out of prison, things were not good. Not good at all. Let me throw some key words at you here. Codependent relationship, dysfunction, insecurity, allegations of unfaithfulness, drug use, verbal abuse, volatile text messages characterized by mood swings on the part of both parties, escalating extremes of idealism and devaluation played out daily, often in the space of minutes.
Yeah.
That's the description of the relationship between Crystal Graham and Kane Bowman. A 5-month period in both of their young lives that were just awful.
Yeah.
Just absolutely awful. At one point, Kane hit Crystal so hard that he all but broke her jaw.
Yeah, right.
There was an incident earlier involving a knife
Okay.
where there was a struggle, a squabble, a knife was involved, and Crystal actually sent Kane a text message saying, with what you've just done to my jaw, I should have stabbed you when I had the chance.
Okay.
Very volatile.
Absolutely.
Very nasty. Crystal was a young mum. She had a son.
Right.
As a result of all this, though, she moved out.
Okay.
Got out of there. You know,
Right.
just leave, as they
Yes.
say. She actually got out, but that was the only place she had to go,
Yeah, okay.
and all of her stuff was there.
Right.
So she said to Kane, I need to come back and collect my possessions. Don't you come back here. I don't want you here. Yes, I do want you here. No, I don't want you here. That same cycle over again.
Yeah.
She went back to collect her possessions, and that's when it happened.
Okay.
He got angry. He advanced upon her, and on her version of events, she picked up the knife, held it out in front of her, and Kane charged into it.
Right.
As a result, he suffered an eventually fatal stab wound.
Yeah, okay.
Now, Crystal didn't cover herself in glory here. She hid the knife in the freezer. She lied to the police.
Yeah, okay.
Panicked about what was going on.
Yep.
But eventually, she pleaded guilty to manslaughter. And she asked the court to exercise special circumstances.
Okay.
We know that the law that John Rao and the Labor Party brought in says
Yes.
you must serve prison time
Correct.
unless special circumstances can be established.
Okay.
And what defence counsel Heath Barclay SC wanted to argue was, let's go back to the days of Narayan, of Wheatra, of Savchik.
Yes.
Let's recognise that they are unique cases, and let's say these special circumstances are exactly the sort of special circumstances that mean survivors of domestic violence should not have to go to prison.
Okay.
He said the act was excessive, but clearly defensive within the context of an ongoing abusive relationship. In the cycle of domestic violence, we often see victims do go back, that they do put up with things women would not ordinarily put up with, he said. What is she supposed to do? Wait until he punched her in the face again and then defend herself? Is she supposed to cop it before she does anything? You do not have to wait as a victim of domestic violence until you are beaten to defend yourself.
Yeah.
Now, that seems to make complete sense with the long-standing precedents set by the other cases.
Well, it certainly seems to fall into that category of special circumstances, as you stated.
The prosecutors disagreed. They said, look, this is a woman with a knife against an unarmed man. The woman had no visible injuries, and here's the old chestnut, could have left Kane's home at any point prior to the fatal confrontation.
Do we know that? I was gonna say, do we know that for a fact? Do we know that once she had, whether she should have gone back or not was a smart move or whatever? She needed her possessions. We get that. Once she's there on the premises, though, do we know that she had the liberty to leave under her own discretion?
Exactly right.
And I say that because, on what I know of the situation, just from what you put forward, I couldn't confidently say, well, yes, she could have just left. Was she cornered in the situation with him advancing and therefore couldn't leave of her own volition? Reasonable doubt, right?
Reasonable doubt.
I would imagine that what I'm putting forward could potentially offer a reasonable doubt.
And you got to think at this point, Crystal Graham might have been thinking, maybe I should have gone to trial with this. Maybe I shouldn't have pleaded guilty.
Yeah, right.
I've admitted I've done the wrong thing. I've killed the father of my child
Yeah, right.
in extreme circumstances. I know I'm guilty. I'm not running away from it.
Yeah.
I just want some mercy and some understanding of the circumstances in which this occurred.
Yeah.
Maybe I should have gone to trial at this point.
Yeah.
So we get to sentencing.
Yes.
Because, of course, there's no verdict that needs to be delivered. This is a guilty plea.
Absolutely.
And we're before Justice Anne Bampton of the Supreme Court.
Okay.
Yes, listeners, that name does sound familiar.
Yes.
Justice Bampton said, the two of you had engaged in mutual domestic violence, specifically Bowman breaking Graham's jaw and her using a knife against him. So she characterized that first instance of the knife as an attack upon his person. She said, your incident is one of excessive self-defense. However, your response was not proportional to the threat Bowman posed to you. I agree with the prosecution that it was open for you to have left the escalating incident well before you took up the knife. Prosecutors submitted there was no evidence of physical injury to you in the immediate lead-up to your defensive action. You had taken yourself to his premises in circumstances where he had made it clear that you were not welcome. It was open to you to leave, and it must have been in your mind how recent conflicts between you had escalated. And she jailed her for 4 years.
Yeah.
We're right back where we started.
Yeah. Look, there is, and I'll go back to my very first comments when the last episode when we talked about this, those shades of grey. There is no black and white here because technically the commentary from Justice Benton there is in essence correct.
Yeah, isolating that incident, absolutely.
And that's what I'm saying. So there is an absolute element of correctness in those statements that she has made in giving that verdict. I do agree with that. The context of it and therefore the overarching, how that relates to this situation is very, very difficult for me to accept on the surface. It does appear that it was a tumultuous relationship. It was back and forth, elements and examples of violence against each other. She has stated, both of them, he broke your jaw. So that's almost, recognition that, yes, you have had physical harm put upon you. In isolation, in this instance, we can't see that there was any technical imminent danger to you, yet you have ended his life with that knife. So
yeah, but hang on.
Yeah.
Gwenda Savchik was in no immediate danger either. She ended her husband's life with a samurai sword.
Yes.
Rajini Narayan was definitely in no immediate danger. She burned down the entire house, committing a reckless and dangerous act. Neither of those two women went to jail. Noreen Wheatra was in immediate physical danger, took up a knife out of desperation, stabbed in the chest, similar sorts of circumstances, but because Ross Callion's hands were around her throat, even if she had gone to jail, it would have been less jail time than what Crystal Graham got.
Yeah. And look, don't get me wrong, Sean, I'm not agreeing with this situation. I'm understanding that those comments technically are correct. As I say, the context to put them in this premise makes it very difficult to accept.
Well, that's right, because the context is, in a post-Savchik world,
Yes.
Crystal Graham should have received a suspended sentence. That is both the just and the lawful outcome of that precedent. But that precedent doesn't stand anymore because of what happened in the Collier case. This is a Collier case.
Yeah.
Let's isolate this one incident of violence from the overall context and view it as it exists in a crystal ball rather than with its all connective tissue. Let me tell you what the White Ribbon Foundation said to me. Its executive director, Brad Chilcott, because I called him and I said, what do you think of this outcome? And he said, to consider only who committed an act of physical violence in a moment takes it out of the understandings of pattern of abuse and control in relationships. That's the next hurdle that we as a society and as lawmakers and as lawgivers need to jump. We understand violence for violence. We understand violence for psychological abuse. Now we need to massage and alter our law so that we understand patterns of abuse and coercive control. We need to upgrade again.
Look, we started last episode talking about 2003 is where we started this process. And we were looking at it through the lens of your experience over the last 18 years of how has that developed, evolved, amended, been tested in that sense? How's it been applied to situations? And we've seen what looked like, an evolution upwards to an understanding. We then saw it perhaps start to waver and then be turned on its head. And as I sort of stated, as a society, we're not fallible. No one is. We're not infallible. So we're all fallible. And perhaps, we stumbled here because we started this out talking about the concept of, needing to look at situations and evolve our thinking, our understanding, and our cultural sensitivities around all this. You started this out by stating that you were incredibly frustrated by the simplistic, naive idea of just leave. We are right back 18 years later, Sean, as you stated, that verdict, the wording in that talks about you could have left.
We still can't separate ourselves from that incredibly unhelpful, old school style of thinking.
And with that, we're going to wrap up this episode and this complex examination that you and I have put these cases under of, there is no black and white. There is multiple shades of grey. And certainly when we're talking about the intersection of self-defense versus a domestic violence situation, there are no easy answers. And it is naive to think black and white fits. And there is absolutely no one size fits all. What we're going to do next week to sort of further this conversation, Sean, is
we're going to bring in and speak to, and it's our great pleasure to speak to, Zara Abrahimzadeh's family.
Yeah.
We're going to take it all the way back to where we began in this series. We're going to speak to them about their mum, about their experiences with the law, including the police. We're going to speak to them most importantly about what they have done already and what they're continuing to do to further the cause of helping domestic violence survivors get out in the world, endure these experiences, and maybe, just maybe, provide ways to make sure that more women don't end up in the types of situations that we've described in this episode.
Yeah. Until then, we recognise that a lot of this content was sensitive and may have been triggering. And if you found yourself in that situation, please use the following resources: the Domestic Violence Crisis Service on 1300 782 200, Domestic Violence Gateway Service on 1800 800 098, the National Sexual Assault, Domestic and Family Violence Counselling Service on 1800 RESPECT. As Sean mentioned, obviously the Zara Foundation, zarafoundation.org.au, and as I said, as well as the dvsafephone.org website as well. With that, we want to thank everyone for listening to this broadcast, either on 5AA or if you've heard this through iTunes and Spotify. We really, really greatly appreciate everyone going there, rating, reviewing, subscribing to our service and the product we put out. Please help us get our message out to as many people as we can. We always value your feedback, inputs, and you can do that by getting in contact with us on the social media at Just Lawful Podcast on Facebook and Instagram, at Just Lawful Pod on Twitter. You can, of course, follow Sean and all of Adelaide's true crime stuff with the advertiser at Sean Fuster on both Facebook and Twitter. And until we get to speak to the Abrahimzadeh family, and until we speak to you, please enjoy our work, but don't become our work. And we'll speak to you on the next episode of just lawful.